Welcome to another episode of the Daily Remedy Videocast. Today we're going to discuss something that has been on top of heart and minds for so many people, yet hardly ever discussed at its truly fundamental level. And that is, why can't healthcare and law get along? It would make sense that the two would naturally align. Healthcare has no shortage of rules, regulations, and law, much the same. But for whatever reason, particularly in the modern United States, law always seems to come into conflict with healthcare, whether that's abortion, opioids, vaping, gun control, you name it, climate change, whatever you want to add to that bucket of whatever. But at its fundamental level, there are two main components that we have to look at to really understand why healthcare and law do not get along. Number one, distribution of burdens. Number two, the elemental and essential framework of analysis. Now, I know that these are a lot of words, a lot of multi-syllable big words that can mean a whole lot of nothing. But let's break it down and let's talk through what each of the two mean so we can understand what it is that creates all these problems with healthcare and law. Let's start with the first one, the distribution of burdens. It's a legal concept that really only hits the foray when you're talking to those true constitutionalists, those originalists who've read the Constitution and talk about clause this, article that. And what it really amounts to is that things have to be fair. There has to be a fair distribution of burdens imposed on select individuals that go across society fairly. And that's where the concept of tax comes from. We have different tax brackets, different tax rates, depending on where you are. That all has to do with the distribution of burdens. In Seattle, you have a certain tax rate. In Toledo, Ohio, you have another tax rate. The burden of providing goods, of living in those environments, is different. Therefore, the tax should be different. Now, it's easy to understand that when you're looking at regional taxes or regional cost of living, but it becomes much more difficult when you're looking at it from the perspective of a burden is not perspective of healthcare. Because in healthcare, just a single act or a single decision. It's the range of secondary and tertiary consequences that can happen with the implementation of a law on healthcare behavior. Healthcare behavior is very complex. Think of it almost like this soup. What a law tries to do is draw a line in healthcare behavior regulating it. But as a soup, it's just going to move around. It's not beholden to that particular line. The movement of the soup around that line, those are the secondary and tertiary consequences. May not be the best example, but next time you're eating soup, think about that. Think about healthcare and law while you're eating soup, huh? Why not? But seriously, when you're talking about distribution of burdens in healthcare, you have to keep in mind the secondary and tertiary consequences. Formerly, they're called second and third order consequences, but we keep it simple because we don't want too many words here. These consequences impact how and why people will behave relative to a law. Let's take abortion for an example. There was in Louisiana a proposed law that would require all abortion providers to have hospital admitting privileges. Seems to make sense. If you're going to provide an abortion in the outpatient setting that's outside of the hospital, you may want to have admitting privileges should a consequence arise. But that law reduced the number of abortion providers to single digits. So the idea was by imposing that rule, the total access to abortion dramatically decreased. That law was ruled unconstitutional by the Supreme Court precisely because the distribution of burden clauses. That law placed the risk of a complication over the risk of access, further tilting the distribution away from a. You start to get why healthcare behavior and healthcare law don't really get along, away from a fair and equitable balance that all laws should have. So when you think from that framework and to generalize it, why healthcare and law don't get along, because the distribution of burden as imposed by many laws only focus on one or two things in relation to that healthcare behavior and not the full range of behavior. And it's nearly impossible to create those types of laws. Just imagine how much writing would have to go into that. Now, lawyers love to write and they love to talk, but they fail to understand the complexity of healthcare behavior when they write and debate over healthcare legislation. And as a result, many healthcare laws violate the distribution of burden clauses. And the reason why they do that goes to our second point: essential versus elemental framework of healthcare law and healthcare behavior. Looking at something essentially means you're looking at something as a whole. You're looking at the entire vision. It's like when you're looking at art, you look at the whole piece. You don't just look at that little squiggly line there, that little thing over there. You look at the whole piece because you look at art holistically. You look at it from its essence. In contrast, an elemental approach to analysis means you look at individual pieces. That squiggly line does matter. That little thing over there, whatever it's doing, that matters too. But most artists would tell you look at the whole and then focus on the parts. Start with an essential analysis and then focus on an elemental analysis. In healthcare, we look at things essentially. We look at the whole patient. We look at the whole medical condition. When a patient presents with high blood pressure, let's say a 67-year-old Caucasian male with a history of hypertension, we focus on medication compliance, diet, overall stress, and we integrate all of that together to identify what are the risk factors that would predispose that patient to poor blood control. In law, and I'm sure you know where I'm getting here, we focus on the opposite. We look at elemental frameworks. So that little squiggly line, that's more important than the whole picture of art. That one stipulation, that one regulation, that matters more than the whole of patient care. Because if that stipulation or regulation is not met, the whole of care is violated, is in violation as per the law. Whether that's a civil violation or criminal violation depends on the underlying law. But the general idea is that one component, that one element can then dictate the entire perspective, the entire essential look of healthcare behavior. For the abortion law that I gave in an example, they were looking at complication rates, that one component, complication rates of abortion that require the patient receiving an abortion to be rushed to the hospital. That one framework, that one element, then became the basis for a law that a healthcare provider offering abortions must have access to the hospital nearby where they're performing the abortions. But the secondary and tertiary consequences were violated as a result of the decreased access to an abortion. Now, if the law were to take into account the essential framework of abortion in the state of Louisiana, it would not have approached the law in that way, but it focused from an elemental framework and looked at the law through one stipulation: hospital admitting privileges. And that lies the genesis of the disconnect between healthcare and law. The distribution of burdens in healthcare is far more complex than the law allows for. The secondary and tertiary consequences are not fully appreciated in many laws, and the distribution of burden is violated precisely because the way we look at healthcare and law differs fundamentally. In healthcare, we look at things in its essence. In law, we look at things through its elemental framework. And that disparity in outlook creates a disconnect in how the two align. Now, if you stuck with me this long, I think you get the general gist. There are fundamental cognitive failures in our understanding of healthcare and law that lead to the array of polarizations can all be distilled down to these two core concepts: distribution of burden, elemental conflicts, and never ending debates for all healthcare issues. But fundamentally, a essential framework of law. Once you look at healthcare issues through those two concepts, you will begin to see patterns emerge. You will begin to see why gun control is so hotly debated, why abortion is the debate that never ends, and the right way opioids, vaping, and any other issue becomes so polarized. And with that, a good day. Thank you.